Hi, my name is Larry Newman. I'm a traffic defense attorney, DWI attorney, criminal defense attorney in the upstate region of New York, the Finger Lakes specifically. Today I want to talk to you about using a legal fiction. That means that somebody would plead to something that they didn't really do to cover something else that they did. So sometimes we're able to creatively, I call it creative lawyering, figure out something so that the judge is happy and the prosecutor is happy. So I'm going to give you one of my situations that we had. We had a person that had a whole bunch of moving violations. Speeding tickets, stop signs, failure to use turn signals, careless driving. I mean, it was about 6 or 7 tickets. The cop just kept writing and writing and writing and writing and writing. He had all these tickets together. If we would have totaled up all the points, it would have been ridiculous. We're talking like 13 to 15 points and all kinds of fines and a surcharge for every single thing. But the bigger issue is, at 11-point level, you lose your driver's license. So that's what's the big deal of this particular case. So the creative lawyering came in because I thought, can we take this package of crap? Let's call it what it is. It's a package of a lot of tickets. And could we instead insert something that everybody could live with? And what would that thing be? So what a prosecutor sometimes wants, or a judge sometimes wants, they want to hold something over somebody. The thing is, with a traffic ticket or a speeding ticket, you don't have the ability to what's called put a conditional discharge on it. In other words, you can't put something like a timeline or hold something over them in case they screw up in the future to come back and then to reopen something. But you can put a conditional discharge. You can't put it on a disorderly conduct charge. It's a low-level violation. It just means like disturbing the peace. It's a public annoyance. But you can't put a conditional discharge on that. And what that gives the ability for the judge to do or the prosecutor to do is, if this person over the course of a year, that's the usual time period of a conditional discharge is 1 year, if they screw up, then you can come back, you can put them in jail for up to 15 days, which is really 10 days, but still, it's something to hold over their head. So in this particular case with this person, it was a great plea offer, I thought, and so did the judge and so did the prosecutor. They were all happy with it, including my client, because they're able to take all these tickets that would have affected their driver's license and their DMV history and their auto insurance and instead trade it all in on a disorderly conduct charge, which had a fine, had a surcharge, but then had this conditional discharge attached to it. And of course, he was good for the next year, didn't have any problems, thank God, or else we would have come back to court and the judge would have remembered all those tickets, which couldn't go back to the tickets, but we couldn't go back to consider that the conditional discharge had been violated, and then he could get sentenced up to 15 days on the disorderly conduct charge. That's why they were able to do that, and that's why they wanted that. They were all happy because I was able to get a CD placed on something to say, hey, listen, we're going to keep this person to be good because now he has something hanging over him. So remember, there's different ways to, as they say, skin the cat. It's a horrible expression, but there's different ways to get things done. And then a legal fiction means that we're trading something that didn't happen for something that didn't happen for something that did happen. So if you have any questions about your DWI case, traffic violation case, these types of cases that we handle, either give us a call or shoot us an email. I'll be more than happy to discuss it with you. And thanks for watching this video.